Thank you for attending this way, and the rules are going to be the same. Each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes, and you just need to let me know. I just wanted to make sure before we began that everybody could see and hear okay, and it sounds like both attorneys can and the judges can. So this is State of Ohio versus Stanley Jalowiec, and you may proceed. Oh, I want to remind you, obviously, even though we are on Zoom, we're still recording this and we'll put it on YouTube.
Thank you, Your Honor. May it please the court. My name is Richard Klein and I represent Mr. Jalowiec. I would like to reserve 3 minutes for rebuttal. This is the second appeal from Mr. Jalowiec's request for a new trial based on Hurst versus Florida. As the court will recall, in 2016, the Hurst opinion of the United States Supreme Court held that Florida's capital sentencing scheme was unconstitutional and violated the Sixth Amendment because Florida's statute allowed a trial court to impose a death sentence based upon a mere jury recommendation. After Hurst, Mr. Jalowiec filed a motion for leave to file a new trial motion, and that new trial motion was attached to his motion for leave, and it requested a new mitigation hearing. Mr. Jalowiec rested that motion on Hurst. He also raised an as-applied challenge to Ohio's constitutional sentencing scheme based on Hurst by asserting that Ohio's practice of allowing trial courts to instruct juries that their sentencing verdicts were mere recommendations was also a Sixth Amendment violation. The trial court did not initially rule on Mr. Jalowiec's request for leave to file his motion for a new trial. Instead, the trial court denied the motion on its merits. We appealed, and on appeal about a year ago, this court remanded to Mr. Jalowiec's appeal to the trial court with instructions to address two concerns. First, whether Mr. Jalowiec's motion for leave to file was timely, and second, to specifically address Mr. Jalowiec's as-applied challenge. The trial court resolved the first issue by finding that Mr. Jalowiec had shown, by clear and convincing proof, that he was unavoidably prevented from filing his motion for a new trial. So today's issue, the issue before the court, is whether the trial court adequately addressed the second question, and that is Mr. Jalowiec's as-applied challenge to the constitutionality of Ohio's sentencing scheme after Hurst. First, I will note that the trial court denied Mr. Jalowiec's as-applied challenge and cited res judicata. However, the trial court improperly applied the res judicata doctrine to deny Mr. Jalowiec's claim because the claim raised in this appeal did not even exist in 1998 when Mr. Jalowiec's first appeal was heard. The issue raised on direct appeal in 1998 was an Eighth Amendment challenge based on Caldwell versus Mississippi, a 1985 United States Supreme Court opinion. In Caldwell, the U.S. Supreme Court held that it was an Eighth Amendment violation to, quote, rest a death sentence on a determination made by a sentencer who has been led to believe that the responsibility for determining an appropriateness of the defendant's death rest elsewhere, close quotes. When Caldwell was decided in 1985, and when Mr. Jalowiec's direct appeal was decided in 1998, no court anywhere had ever recognized that the Sixth Amendment required that a jury decide every fact necessary before a court imposes a death sentence. So Hurst announced that understanding of the Sixth Amendment for the very first time in 2016. The issue that Mr. Jalowiec is raising here is that the Caldwell violation, the repeated statements to the trial court that their sentencing verdict was a mere recommendation, now implicates two constitutional rights: the Eighth Amendment right to avoid cruel and unusual punishments, and the Sixth Amendment right to have a jury determine all of the facts necessary to impose death. So the issue presented here was not the same issue presented in Mr. Jalowiec's 1998 appeal, and the trial court erred by finding that this claim was barred by res judicata. The court did go on and say even if res judicata doesn't apply, that nothing, and I think I'm quoting the trial court correctly here, there is nothing in the Hurst or Belton decisions that suggests that it is constitutionally problematic to inform potential jurors that the decision to impose death is a recommendation to the court. But that trial court finding ignores the plain words of Hearst. Hearst said, and I quote, "The Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death. A jury's mere recommendation is not enough." Trial court also relied on State versus Melton. I'm sorry, I'm misspeaking. State versus Belton and State versus Mason, two Ohio Supreme Court decisions, and that reliance was inappropriate. In Mason, the Ohio Supreme Court denied a facial challenge to Ohio's capital scheme because it held that Ohio juries must make a factual finding that the aggravating circumstance proven at trial outweighs any mitigating factors. In making that holding, the Mason court also relied on Belton. In both Belton and Mason, however, the court was addressing a facial challenge to the statute. Neither Belton nor Mason addressed an as-applied challenge to the reliability of a jury sentencing verdict after that jury had been repeatedly told that their verdict was a mere recommendation. But that is precisely what happened in this case. Their jury was told over and over that their sentencing verdict was a mere recommendation. At one point, the trial judge even said, "That's why I get the big bucks," referring to the judge's responsibility to determine whether the accused should live or die. The issue before the, yes.
Counsel, one of the differences, though, with Ohio's procedure is that the jury does have to find an aggravating circumstance.
That's correct, Your Honor. The jury does have to find aggravating circumstances.
Beyond reasonable doubt.
Yes, they do, Your Honor. And that's why the discussion in Mason on a facial challenge focused on that jury determination. The concern raised here is not that the jury was relieved of that obligation. The concern here is that the jury was relieved of the weight and importance of their decision by being told over and over that their decision was a mere recommendation. No court in Ohio or elsewhere has ever addressed the question of whether it violates the Sixth Amendment and the Eighth Amendment to allow a trial court to entrust to a jury its constitutional duty to find facts necessary to impose a death sentence while simultaneously telling that jury that their fact-finding role is merely advisory, that it results in a mere recommendation. Belton and Mason survived a constitutional challenge because the Ohio Supreme Court concluded that Ohio's scheme requiring juries to make factual findings necessary before a sentence is imposed. And I could argue with that as a defense lawyer. We could take exception to that ruling, but it is the ruling, and that's where we are. Ultimately, the United States Supreme Court will have to decide whether that's an accurate read of the Eighth and Sixth Amendments. But what should be clear to all of us is that Belton and Mason opinions both assumed that we would have a jury properly instructed and properly functioning to make the required findings, not a jury that had been repeatedly told that their sentencing verdict was merely a recommendation. And as Hearst made clear, that circumstance violates the Sixth Amendment.
And counsel, I get
Yes.
what you're arguing in this case specifically with the applied, is the fact that even though cases have said before that it's not the best practice to tell the jury they're only doing a recommendation, it's still constitutional. But you're saying, and correct me if I'm wrong, if I'm misunderstanding you, but you're saying because in this particular case, it was done repeatedly, and that's what makes it different.
That's partly correct, Your Honor. Yes, it is partly because it happened so often in this case, and it's partly because at the time that those other cases were decided, where the court said, not best practices, you shouldn't do it, we don't want you to do it. At the time those cases were decided, there was no recognition by any court at any level that the Sixth Amendment placed this burden of fact-finding on the jury. And so in fact, there's language in those same cases that says the jury is not the fact finder. The jury is not the sentencing body. The sole sentencing power lies with the court. So Hurst represented a sea shift in the analysis. And so after Hurst, we know that the Sixth Amendment requires the jury to make all of the factual findings necessary to impose death. And Caldwell taught us that it's an Eighth Amendment violation to diminish the gravity of that issue before the jury and to diminish the jury's sense of personal responsibility for its verdict. Yet that's exactly what happened in this case.
If I may,
yes, Your
you have stated over and over again that it was just a mere recommendation. Well, the word mere sort of trivializes the word recommendation. It takes away from the teeth of the word recommendation. Did the court continue to use the word, this is a mere recommendation, or is that words you're using today?
I'm hesitating only because I'm trying to remember the record and make sure I don't misrepresent it to the court. My recollection is that the trial court used the words recommendation. I don't recall the trial court specifically using the phrase mere recommendation. I use that phrase because that's the phrase used in Hurst.
You have about 1 minute before you enter your 3-minute rebuttal time, if you want to save that or if you want to proceed.
Thank you, Your Honor. I would just ask the court to vacate Mr. Jalowiec's death sentence, remand the case to the trial court for a new mitigation hearing, and instruct that hearing to occur before a jury that is free of the suggestion that their verdict is a recommendation and not the awesome and important task that it truly is. Thank you, Your Honor.
Thank you. Is the state ready to proceed?
Yes, I am. Thank you, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. And first, I'd like to address the procedural posture of this case a little bit. And the issues presented are before this court today because the trial court denied Jalowiec's motion for a new trial. And as we're aware, the Jalowiec's motion attacked the constitutionality of Ohio's death penalty statute by relying on the United States Supreme Court 2016 decision in Hurst, which struck down Florida's death penalty scheme as unconstitutional. And viewing this appeal in its procedural context is important because it establishes this court's standard of review. In his merit brief, Jalowiec suggested that this court should review the appeal under a de novo standard of review because he claims his appeal involves purely legal issues. The state submits, however, that this court should review the appeal under an abuse of discretion standard. And that's important because this court and the Ohio Supreme Court has held that a motion for a new trial under Criminal 33 is addressed to the sound discretion of the trial court and cannot be reversed on appeal absent an abuse of discretion. And an abuse of discretion connotes that the trial court's decision is arbitrary, unreasonable, or capricious. And this court then is to grant deference to the trial court's decision and cannot substitute its judgment for the trial court's.
Counsel, I understand what you're saying, but isn't there, though, even when there's an abuse of discretion standard, you have to look at the underlying issues to determine what maybe our standard review is for the underlying issues. And since this is a constitutional issue, wouldn't that make it a de novo review then?
We would disagree that it's a de novo review and submit that it is an abuse of discretion. There's a case, State v. Jones, I think out of the 9th District, that reviewed the first issue for a motion for new trial, and the court applied an abuse of discretion standard.
Thank you.
Yes. And Jalowiec, in his motion for new trial, he presented both a facial and an as-applied challenge to Ohio's death penalty statute. And I think that we have to review in this appeal both his facial and as-applied challenges to the death penalty statute to put his as-applied challenge into context. In Hearst, the U.S. Supreme Court invalidated Florida's capital sentencing statute because it limited the jury's role in sentencing to an advisory recommendation and did not require the jury to make the critical findings necessary to impose the death sentence. In Hearst, the judge increased the authorized punishment from life to death based on her own fact-finding. As we are aware, the Ohio Supreme Court has expressly recognized that Ohio's capital sentencing scheme is unlike the laws at issue in Hearst and has expressly rejected the same arguments Jalowiec makes here. That's the Supreme Court's decision in State v. Mason, the Ohio Supreme Court's decision in State v. Mason. In Mason, the court highlighted the differences between Ohio and Florida's death penalty statute. As I think you pointed out, Judge Carr, in Ohio, a capital case does not proceed to the sentencing phase until after the fact finder finds a defendant guilty of one or more of the aggravated circumstances. That's when a capital defendant is rendered death penalty eligible. And it is not possible to make a factual finding during the sentencing phase that exposes a defendant to a greater punishment. And that is what differentiates the Ohio statute from that was at issue in Florida. So simply put, the arguments set forth regarding the constitutionality of Ohio's capital sentencing scheme were rejected in Mason and have consistently been rejected since. So the trial court did not abuse its discretion in denying Mason's facial challenge because it was bound by the Ohio Supreme Court's decision in Mason. This court is required to follow that precedent as well. As to the as-applied challenge, Jalowiec is arguing that the specific application of Hearst to the facts of his own case warrant relief despite the Ohio Supreme Court's holding in Mason, and premises that argument on the assertion that the trial court and the attorneys in his case emphasized that the role of the jury was only to recommend punishment, and that the use of the word recommend impermissibly diminishes the role and responsibility of the jury. We would submit, though, that Jalowiec did raise the same argument in his direct appeal in 1998, and that this claim is barred by res judicata. In his brief, Jalowiec raises the Caldwell argument, and that case was decided, I believe, in 1985 as to bolster his as-applied challenge. And the court, therefore, that argument was available to Jalowiec as far back as his direct appeal. And the court did, in this case, argue that, or did decide that that res judicata was a grounds to deny Jalowiec's motion for a new trial, but it did, in the alternative, reach the merits of his as-applied challenge. So here, even if this court were to reach the merits of Jalowiec's as-applied challenge, the state submits that it has alternative grounds to affirm. The state submits that the Ohio Supreme Court has repeatedly held that references by the trial court or attorneys to death penalty recommendations withstand constitutional scrutiny. We recognize that this term may be disfavored, but the practice has not been declared to violate the Sixth Amendment. The trial court itself did note that there was nothing constitutionally problematic to inform a juror that the decision to impose a death sentence is a recommendation. And Jalowiec's as-applied challenge hangs on the statement taken from Hearst that a jury's mere recommendation is not enough. That is the statement that he's taking from Hearst to make his as-applied challenge. As Jalowiec does here, the appellant in Mason argued that Ohio's capital sentencing scheme was unconstitutional because it permitted a jury to merely recommend a death sentence and emphasized the statement in Hurst that a jury's mere recommendation is not enough. The Ohio Supreme Court noted that in doing so, Mason failed to appreciate the difference between the process by which Ohio reaches its death recommendation and the Florida process at issue in Hurst. So the statement emphasized by Jalowiec here that a jury's mere recommendation is not enough must be placed in context. The reason a jury recommendation was not enough in Hurst was because the Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death. However, the Florida death penalty statute did not require the jury to make the critical findings necessary to impose the death penalty. In contrast, Ohio law requires a jury to find the defendant guilty beyond a reasonable doubt of at least one aggravating circumstance before the matter proceeds to the penalty phase, when the jury can recommend a death sentence. The requirement that the jury make this specific and critical finding is what differentiates Ohio's statutory scheme from Florida and satisfies the Sixth Amendment. Therefore, for purposes of his as-applied constitutional challenge, Jalowiec's reliance on the Hurst language that a jury's mere recommendation is not enough is taken out of context and misplaced in light of Mason. Ultimately, in raising his as-applied constitutional challenge, Jalowiec has failed to establish that the Ohio death penalty statute is unconstitutional when applied to the existing set of facts in his case. Accordingly, we would submit that the trial court did not abuse its discretion in denying Jalowiec's motion for a new trial. The state would respectfully urge this court to overrule Jalowiec's 2 assignments of error, the facial challenge and the as-applied challenge, and affirm the judgment of the trial court.
Thank you. Are there any questions from the panel members? No. Then thank you very much.
Thank you.
Counsel, you have 3.5 minutes remaining. You may begin. Mr. Klein, you want to unmute yourself? Mr. Klein.
Sorry about that.
Oh, there.
Yeah,
that's
sorry.
okay. I was like, I can't hear you. You have 3.5 minutes.
Thank you very much. And I would agree with my colleague from the state that Mason controls this court's decision on the facial challenge to the constitutionality of Ohio's capital statutes. Like I said in my argument, I may disagree with that. Some of you may disagree with that, but we are all bound by the Ohio Supreme Court's decision in Mason, and so I don't quarrel with that. The focus of today's argument is the as-applied challenge. As I indicated earlier, ultimately the United States Supreme Court will have to tell us whether the reach of the Sixth and the Eighth Amendment, as I've described it, go as far as I want them to go. But for today, we are all bound by Mason on the facial challenge. I disagree with my colleague that the standard of review is an abuse of discretion. I think that it is properly a de novo review because this is a legal constitutional question. However, even if this court were to conclude that an abuse of discretion standard applies, I think we've met that standard. The facts necessary to impose death include a determination by a jury that is free from the bias and free from the diminished understanding of the importance of their actions. And so the trial court did not address that concern at all in their analysis of the as-applied challenge. And I would just refer the court to State versus Keith, State versus Williams, and State versus Buell, 3 decisions where the Ohio Supreme Court made it abundantly clear that the better practice is to not use the term recommendation, to not tell the jury that their verdict is a recommendation, and to not in any way diminish the importance of the jury's role. Now, when those cases were decided, Hearst was not decided. So there was no Sixth Amendment discussion in those cases because none of those cases raised the Sixth Amendment issue. But in those cases, the court made it clear that the better practice is not to do what happened here. And what happened here happened repeatedly. It happened, I cite on pages, well, I'm sorry, I don't remember the exact pages, but in the merit brief, I think there's 4 or 5 pages of quotes where those sorts of conversations go on between all of the parties, really, the judge, the prosecutor, and even sometimes defense counsel. So I would suggest to this court that the question that Jalowiec is asking is truly a question of first impression in Ohio. I don't think there's been a court that has been asked to rule expressly on the Hearst application to an as-applied challenge with the kind of record that we have here. And so I would ask the court to grant relief, vacate the verdict, and remand for a new sentencing hearing.
I do have a question though.
Yes.
If you were, based on what you're arguing, if the trial court weren't to tell the jurors that it's not just a mere recommendation, this is what it's going to be. Whatever you decide, it is what it is. If you decided that it's a death penalty, it is. And then it turns out that the trial court later on in mitigation or decides that, you know what, it's not, it doesn't. Is it your suggestion then that whatever the jury decides is what it is, and the trial court should have no ability to look at the mitigating factors and make a determination other than what the jury is imposing? Or I don't understand what you're suggesting should happen.
Yeah, I think that's a great question, Judge, and I apologize if I've added confusion to the issue. I think there's a distinction between the trial judge exercising her statutory duty to do an independent review of the aggravators and mitigators and telling the jury that their verdict is really only a recommendation. I think there's a big difference between those two.
Well, but then what do you tell the jury? It's not a recommendation, it's what? Because if the trial court's going to come back later and say, no, I'm not going to go with what you decided, I'm going to do this thing over here, what is it that the jury's doing then? It's not a recommendation.
I think that it is a jury verdict, and just like a judgment NOV, the trial judge in a civil case doesn't tell a jury, tell me your verdict, but understand I might disagree with that verdict and I might enter a judgment NOV. There's no need to have that discussion with the jury. The jury needs to understand that their verdict is their verdict, and it should have all of the solemnness, all of the weight, all of the gravity that goes with that decision. And the danger that we have as a result of the way that this jury was, the interactions with the court and this jury, is that it diminished the jury's sense of responsibility for that verdict. We can avoid that by simply saying to the jury, your verdict is your verdict. It must be one that you are completely satisfied with. And then independent of that, if a trial judge says, I think the jury lost its way here, and that has happened, I think it's happened a few times.
Counsel,
yes.
You're over time. I was just allowing you to answer.
All right, thank you very much. I apologize for the
No.
exuberance.
She asked the question, so I wanted you to answer. But okay, well, the court is grateful for your arguments, and you both presented compelling arguments and did a great job. And we will take the matter under advisement and issue a written opinion that will be sent to both sides. And you probably, both of you already know as well that we release on our website and on the Supreme Court as well when our opinions are issued. So thank you very much. And
thank
everybody, thank you again for participating in this manner. It's maybe not quite as good as the courtroom, but it gets the job done. So I'm very happy and grateful for it. Okay,
Thank you for the
so much.
opportunity.
Thank you.
Have a good day and stay safe.